got time, we'll try and squeeze in a couple of questions here from our audience. These are open to both of our panelists, but Tom, this question did drop in during your segment, and it relates to the search of a debtor. Now, if a company conducts a UCC search of a debtor where under the wrong entity, so i.e. just having LLC instead of L.C, is that something that would be considered a complete search or not?
No, I don't think so, because Article 9 requires that how a debtor is identified on a financing statement not be unreasonably confusing or misleading. And the code requires that the name of an organization debtor, and as John said earlier, depending on which option your state applies, an individual usually goes by the most current state driver's license. But let's talk about a corporation or an LLC. You have to look, as John said, on its certificate of formation or articles of organization. That's what's going to be the guide as to what has to be on the financing statement. And that's called in the code the public organic document. If the name is ABC, LLC, no periods, but the search company searches it with periods in LLC, they may not come up with filings against the proper name. Now, I can tell you that when I do searches on the New Jersey State website, there have been times where I'll have misinformation and I'll plug in the name ABC, L.C, and nothing will come up. And then I'll try it without the periods and I'll find what I'm looking for. So generally, the code wants the search to be done according to the search logic of the particular filing office. And if that search logic is going to prevent you from finding filings against the proper name because you insert periods, for example, in the suffix LLC, then no, I don't think it's a complete search.
Yeah. I'll just add, Tom, if you might get lucky if the search logic of that the filing office uses to pick up, LLC or L.C. But man, just make sure you use the name on the public organic document, and that's really what you need to go with. And because if you do search that name, that you're protected.
Right. And just another point. When you're doing a loan and you're representing the lender, you're going to get all kinds of due diligence corporate documents, including, for example, a good standing certificate. I've had examples in New Jersey where the name on the good standing certificate is not the name on the public organic document, the certificate of formation. So don't think that you can rely on what's on, a certificate of good standing generated after the actual filing. Go only by what's on the certificate of formation.
Exactly. Yeah. Good point.
Thank you so much. We'll wrap up with this last question here, and it was something that was discussed throughout today's presentation: the importance of retaining a priority position. In your opinion, the collective panel, in your opinion, what should someone consider to retain that priority position status? So, what could a secured lender do post-closing to ensure that security interest remains in its priority position?
I'll take a stab at that one.
Yeah.
There are a couple of different ways the financing statement in particular can lose its effectiveness, and I hit on those in one of my slides. And one Tom mentioned is the financing statement will lapse and no longer be effective after 5 years unless within 6 months prior to that 5-year anniversary you file a continuation. Your financing statement can also become be ineffective to perfect if your debtor moves its location to another state. For example, some debtors may start out and just use it as an Iowa corporation, and then they decide for good reason perhaps to reincorporate in Delaware. well, and then become a Delaware corporation. Again, you can, if you don't take steps to then file in Delaware, you could lose your financing statement effectiveness. So as Tom emphasized, you need to keep tabs on your debtor, what its name and its status and location to preserve your perfection under that original financing statement.
And something even easier than that is just a name change. If you have, for example, a corporate debtor and they change their name from ABC Corp to DEF Corp, same thing as John was mentioning. You have a very limited amount of time as a secured lender to make sure that your priority perfected position continues. And if you don't file an amendment in that case within 4 months of the change, and the threshold is that the name change make it sufficiently misleading that the search logic would cause you not to find it. But if you don't file an amendment with the new name on it within 4 months of that event, certainly as to any after acquired property after that 4-month period, you're going to lose your priority. Mm-hmm. And there are equal equally important time changes when you have, as John just alluded to, a change in location, or when there's, for example, a new debtor because there's a merger or an acquisition or something, and or collateral is transferred to somebody else. So, most security agreements that I see always contain a representation by the debtor that A, they're not going to do that, and B, if they do, they're going to let you know. But if they don't, the fact that you may find out about it 6 months after it occurred isn't going to help you, because it's not a question of when you find out about it as secured lender. It's a question of what's 4 months from the date of the event that caused it to become, sufficiently misleading. So it's really important for a secured lender, whatever it is that they do, to monitor any changes to their debtor's status, location, whether they've sold collateral subject to the lien, etc. Because if you don't, you stand a very good chance of losing your priority position.